So we're going to be discussing the pros and cons about punishment, name and shame. First of all, we're going to discuss if it's an effective deterrent in its own right. And Zach, I think you were going to be leading this one.
Yeah, I can bring some points up for this. The idea that it's an effective deterrent is an important discussion to have. However, that especially for sexual crimes, the recidivism of them in general is actually extraordinarily low compared to other crimes. It's in a lot of cases half compared to normal crimes, whereas the recidivism is the biggest issue for those. So for the sexual crimes, which is the most important one to discuss as it is the only legal form of naming and shaming, the naming and shaming as an effective deterrent is not exactly prevalent because it doesn't actually have any effect on recidivism to be a part of a database that people can access. It doesn't affect recidivism. It has a slight effect on first-time offenders. It was noted in a particular state in America, they saw a drop of 11% of first-time offenders after the first 10 years after the database was initialized. So for first-time offences, it is an effective deterrent. However, for recidivism, there's a negligible effect in almost every environment where it's put forth.
Just for clarification, we're talking about Western Australia?
We are talking about Western Australia. However, it is important to note that the level of research into whether or not the Western Australia's, how they've handled the database for sexual criminals, there isn't a lot of research into whether or not it has been effective as compared to how it was done prior to in accord with all the other states before they put forth their limited access law, which was in about 2006, I believe.
I think it's one of those things, it's quite a hard thing to measure in a way. How do you measure the impact that that naming and shaming has had on first-time offenders, because they're likely to fall into that sort of the black figure of crime in a way. They're not reported because they're not offending. So how can we possibly gauge a statistic on whether the deterrent has been effective or not, and to what extent it's been effective if they never offend?
Yeah, sorry, Jason, you go.
Yeah, the court certainly recognised that naming and shaming, does have a element of punishment. In a New South Wales case of Enfield versus the Queen, the court noted that the court is obligated to mitigate someone's sentence if there has been a form of naming and shaming, especially when it causes some sort of psychological effect on the person that could be taken into account as additional punishment.
Yeah, so I guess it's really controversial in a way as well. So you can't, as Eliza was saying, you can't really tell if it works or not, because a lot of the time it's the media hype that'll go and put people's names in the spotlight, and that's before a suppression order sometimes has even been lifted. So yeah, it's very controversial. You were saying, Jason, that the impact it takes on someone's mental health. I personally don't think it's a very good idea, but that's just me.
Well, when you're comparing it to if a court is willing to say that the degree of naming and shaming that's going on it's justified to reduce a prison sentence, keeping in mind that prison is the harshest punishment we have. If the courts are comparing, the psychological damage that naming and shaming can do to prison, then it's safe to say that the psychological effect is profound.
Well, how do you think that it would act as a precautionary principle? Maybe not even so much as a punishment, but more so as a warning to the general public. Do you reckon it could act more towards that than it would act towards punishing the offender? I think you had some stuff to say on this, Jason and Eliza.
Well, certainly I think that there's that debate about whether, hypothetically, say a family wants to move into a particular neighbourhood, whether they've got the right to know that neighbourhood is sort of safe and free from past offenders. Recidivism is still active, even if it's, you know, they're not in particularly high statistics. It is still, recidivism is still possible. I think that sort of cures for sexual offenders are few and far between, if they even exist. And so with that in mind, do the public and do families moving to a particular area have the right to know that area is safe? Is it a risk? They need to be able to have all the information to make an informed assessment before they take that risk.
Well, I think it comes down to perceived danger versus actual danger. When you look, sexual offences, for the most part, the victim and the offender are known to each other, and the offender is generally somebody who's in a position of power over the victim. So the cases where you have a sexual offence against a stranger are very few and far between. So having knowledge that there's a known sexual offender in the community, while it might make the community feel better, there doesn't seem to be any evidence that it will act as a general deterrent, or it will enable people to stop a potential offence from happening.
So what about in other offences that aren't just necessarily sexual offenders? So like, do you think that the public should generally have an idea of the outcome of like court cases? And if so, to like what extent do you think that the public should have that knowledge? Like, should it go to only part of the case or the entire outcome?
Well, certainly, in my opinion, I think that the public does have a right to access to justice, and that includes information about the outcomes of trials and information about offenders. Obviously, you know, not including personal information such as their address, which would encourage vigilantism, a word which I still don't know how to pronounce. I think that the public right to information is certainly why open trials are held. I think that the fact that George Pell's trial was closed stirred a lot of controversy, as there was that debate about, you know, whether the public has the right to that sort of knowledge. So sexual offender, regular offender, I think there should be much of muchness.
I think it also is like comes down to what the public do with the knowledge. I mean, like we can find out and some people can respond in really bad ways to that. So I think that's also an important note when considering whether or not the public should know is, considering what they're going to do with that knowledge.
Although that said, like as soon as someone's convicted and sentenced, the sentencing judgment is on public record. All you have to do really is put somebody's name into Lawsight and see if they've got a case against them and see if they've got a judgment against them. It's really that information is already available to the public.
Awesome. Does anyone else have anything to say on that topic before we move on at all?
I'll just quickly mention that although our justice system is quite open and you can most of the time walk into any court proceeding, that it's not particularly convenient. And I think that's one of the big factors why many people don't know the ins and outs of the justice system, is it's just a pain to figure it out. Going to the court website, looking at the timetables, attending court, sitting in on court proceedings, it's just not something that a normal person would do with their time. And I think that's it. Speaking from experience, as someone who has gone through several court proceedings in the past, it's certainly not something that I would voluntarily do again.
I also wonder if the reason there's sort of protection around the openness of trials concerning sexual offenders is in the interest of the victim, and these victims, you know, can often be under the age of 18 years old, and their names are often sort of, I forget the term, but they're not disclosed to the public in, you know, the interest of privacy and protecting that victim. So I think it's sometimes not just about the offender.
Yeah, it's certainly true. You know, sexual crimes are up there in terms of graveness with murder. the difference between a murder and a sexual assault is that the victim of the sexual assault is still alive, and the process of examination and cross-examination, they have to relive that experience, which is obviously goes without saying, that's traumatic, and having to do that not only in front of 12 good men and women of your peers, but also potentially dozens of people in the public gallery would be extremely traumatic to the victim.
Well, so moving on, I've got here to talk about vigilantism. I found a case fairly recently. It's been deleted since, like all history. I can't track it down anywhere. The local news outlet had released an article about a sexual offender who'd already spent his time in prison. I think it was 6 years or something, and they released him back into the public. There was a big write-up about this individual, and they even mentioned like the town that he was residing in, which in this case is a really, really small country town. So everyone knows everyone. I was scrolling through the comments on that, and some of them are absolutely ridiculous. Like people are like not only naming him, but throwing out his address and saying, oh, I know like where he actually lives now. And oh, if I see him on the street, I'm going to kick his head in, or I'm going to like stab him and stuff like that. Wow. So what's everyone's views on like vigilantism and stuff like that? And how do you think a court could go about like potentially leaving a suppression order on, or stopping the public from actually learning of their residents?
Well, I think it sort of would go against the objective of the criminal justice system, which is, preserve the rights for the community, ensured that there's justice for the community, the victim and the offender. An offender is essentially serving a lifelong sentence if they're going to be subject to vigilantism after they've served their years in jail. And so it would undermine the purpose of the sentencing system if if a minor offence is committed, but that shame and that title is, he's wearing that for him, or they are wearing it for life, then that's an issue, I think.
Yeah, I agree on that as well. And I think it's a purpose of the Sentencing Act to rehabilitate a person. And is somebody really going to be rehabilitated if they're, named and shamed and constantly carrying this around and serving a life sentence, even after they've, served their time in jail? Or
that's interesting point as well. In relation to the labeling theories. Well, I think Urgie, you were talking about this like during our last call, because if someone is like being a victim of vigilantism, are they bound to see themselves more as a criminal and not be able to let go and therefore continue their crime spree?
If they're targeted and, treated like, they can't reintegrate into the society once they're released, basically can lead to reoffending as well, and doesn't really help anyone at all. So
it's like if they're named and shamed, if everyone knows them as a criminal, well, some people might just believe, why not be a criminal? Like I have this label, so why not actually do it?
I think it also takes away the whole, if they have been, like that guy that you talked about, he's been let out of prison, and what was the point kind of thing in putting him in prison? Why didn't they just name and shame him in the first place if all this would happen to him? I think it kind of just defeats the purpose of the sentencing.
There's also the factor to consider of why the person was offending in the first place. So generally, somebody that is offending has some deep set issue, usually in their childhood, or they have some social strain that they're going through. And more often than not, it is as simple as they just can't get a job and can't get by, and they end up committing crime as a way of dealing with that. So when you've got somebody that's coming out of prison and they're back and they really want to get a job and they want to move on, they can't do that if they're getting named and shamed, and they get put back in the position that they were before they started offending.
Well, it's sort of like it it shows the limitations of the rational choice theory. If you're applying that and saying, well, every offender has made a rational decision about what, committing an offence, then they should, be the one to bear the repercussions. But of course, it's not the reason why all offenders commit crime. And like you said, Jason, it's sort of, there are subconscious issues that play into why people offend, amongst many other different things. And it's not always a rational decision. And so they're not always aware of the consequences.
Sorry, one of you said before, what's the point of them serving the prison sentence anyway? I actually found an article, I'll link it as well. It was a bloke who was jailed for wielding a shotgun and essentially raping someone at a party. After serving his time,
raping, or they actually raped?
No, they were. It's an interesting read, worth a look into. But after he'd been released from prison, he ended up being cleared by a jury of rape using a shotgun with intent to rape over the same assault. So I'm not too sure if there was a double jeopardy situation. The article's not very clear, but he ended up being cleared he was cleared by a jury of the crime that he was already sentenced for.
Okay.
So his name was posted publicly. So was his town. Actually, it was the same town that I was talking about the other article with. But all of this has been released, and then all of a sudden he's been acquitted. So what happens then?
Well, that's the real reason why courts have a real problem with vigilantism. Is what if you have vigilantism in the community going out and serving justice of their own accord, and it turns out that the person didn't do it.
Mm-hmm.
Well, the point of the criminal justice system is not really to decide whether a person has committed the crime or not. They're to decide from the perspective of the criminal justice system to decide whether or not they're guilty or innocent. And even if they did commit the crime, if the criminal justice system decides that they're innocent, they are innocent. And it's not always fair, but it is how the system was designed to function.
Sorry, just to clarify, I just looked into it a bit more. So he'd already served 14 days pre-sentence, so he was just held until his sentencing date before he was acquitted.
Oh, okay.
So does anyone have any final points to sum up? We've got a minute left if anyone wants to chat about anything in general.
If you liked this podcast, check out our other stuff on our WordPress.
And I'm sure Jason will link in the rest of the videos that we've done as well, somewhere on a side tab.
Yeah, on the side tab, like right there.
Yeah, it'll be in the information thing up here. Feel free to like, subscribe, post in the comments.
You want to hear more about sex offenders? Then subscribe here.